What's up, viewers, subscribers, and agents alike? It's your boy Enlightened Luciferian Prince coming to y'all once again. Welcome. If you're watching this video around children, please remove them from your immediate vicinity. These videos are not for children, as you should know, as it's already indicated in the video description. Um, for the brothers and sisters observing the Eid, enjoy. Alhamdulillah. Enjoy yourself. I mean, you came a long way. You went through the journey. I ain't gonna lie, Ramadan this year went by really fast. Like, I mean, if you do it so often, it just like, but this year just seems like it just went by like, poof, you know what I'm saying? It went by pretty fast, like serious. But alhamdulillah to all the brothers and sisters who observing the Eid, you know what I'm saying, and stay steadfast in the path. But this does not constitute legal advice, nor does it constitute anything anti-government. The sole purpose of this video is for informational, educational purposes only. Now, I want to talk to my quote unquote audience. And it's a more lesser known lesser spoken, not known, but lesser spoken on topic that um I wanted to touch on because of the hardships of the financial market and the misunderstanding that a lot of people have in the respective realm of what we call mortgages. Now I know a lot of people talk about you know, rent and so forth and so on. Well, that's a different story. This is strictly for mortgages and mortgages only. So you don't have to leave no comments in the comment section and ask me about bills or anything like that. We're strictly talking about mortgages in this video. So the title of this video is Mortgages and What You Should Do. Okay? Mortgages, legal definitions, all can be reviewed and studied in Black's Law Dictionary, irrespective of what edition you use. Now, the problem with mortgages, people, I want y'all to understand something. I want you to follow me very, very, very closely. Very closely. Mortgages are nothing more than you loaning yourself your credit to make a purchase on a house. Now, I said it in videos previously, I said it before. The reason why they do foreclosure fraud, we're going to get there in a second, is because you purchased the house through a third party lender. The third party lender itself never presented you with an original contract or an original presentment of what they call receivables, accounts receivables, to declare that they actually have a receipt to say that they loaned you something. They never have it. What do they have? They had access to your trust, which is the social security number, and they have your pledge, which is your signature. The signature is tied to the trust, and the QSIP number and the routing number, which is tied to the social security number, which in and of itself allows them to convey or secure a monetary um, security and to be able to materialize and monetize a promissory note. Now, when they make you promise to pay on something you basically already paid for, what you're basically paying for in a mortgage, and to be very blunt with you and very honest, and I know some people may disagree, but I'm just making it simple because they want to make it complicated. You're paying for the deed to the property. You already bought the house, but they want you to pay back interest on the deed. See, hence the term 9/10 of the law, right? Possession is 9/10 of the law. Well, the 1/10 that you don't have is the deed, which they make themselves appointee over the deed based upon a promise to pay, although it constitutes fraud from its inception. Why does it constitute fraud, you may ask? It's because, first off, they used your trust, but they did not have a SSA 89 form in place. I showed y'all that in previous videos. They never have it. Since they never have a SS 89A, that basically means that there was no agreement between the Social Security Administration and the lender to basically say, hey, we have an agreement with the Social Security Administration to access your trust. They never have it. Okay. Now I'm going to use this in a present tense situation so I can use my own personal reference to the situation because I'm currently dealing with a situation with my sister-in-law who is dealing with a mortgage company, and I spent about 47 minutes on the phone with them yesterday. Okay, I spent about 47 minutes on the phone with them yesterday, and the 47 minutes I spent on the phone with them, in reality, they basically said in but so many words, when we sent the debt validation um, statement to them to basically say we sent it to them on multiple occasions, either via fax or via mail, doesn't matter. It's been well over 80 days and they haven't responded yet. Now, collection attempts may persist and they always will because that's two different departments, okay? So when you're dealing with a mortgage company, just understand collections and the um, risk assessment and escalations, they're totally different departments. You're going to be on the phone talking, even though they have a main line, they're going to always direct you to somebody else. So after I spoke to the senior executive on the matter, because that's the only person that I think would have logically understood what I said, because obviously they're qualified enough to have that position. Basically, in but short, she said basically they're not going to honor the agreement. So she said there's debt verification, but there's no debt validation. So I told her particularly, I said those are two different things. A verification of debt means that you are verifying that you made a debt. But here's the kicker. The validation part means that you have to verify by the verification that the debt is valid. See how the word game played? Debt verification means yes, we understand the instruments which drew up on paper. We get all that. That's your verification, what you're prescribed to furnish to the individual mortgager, basically to basically say, okay, well, this is what it is. Okay, we get that. Fine, black and white. Now they'll turn around and then they'll say, well, we did what we were obliged to do according to the Fair Debt Collection Practices Act, which to an extent is true. However, according to the Fair Debt Collection Practices Act, a debt must be validated in order for it to be a fair collection. You see what I'm saying? So, in order for it to be a fair collection, you must furnish to me a signed and completed debt validation letter. In other words, you must send this to me and all attachments and so forth and so on. You're verifying, we understand, but you must validate. If indeed they fail to validate a debt, here's what I tell people what you can do. Irrespective of going through the private administrative practices of, drawing up private checks and so forth and so on, before you do all that, because that can come second, before you do all that, here's what we'll do. You file a federal lawsuit under the violation of the Fair Debt Collection Practices Act 1692, 1694, and also include Code Section 15 United States Code, subsection 1, and you basically do a 42 United States Code 1983 as an attachment for violation of your right to life. Now, why would it be a civil rights violation? Because basically they're compromising your right to life because they drew up a fraudulent contract. Lenders never loan you anything. I don't give a fuck who watches my channel. I don't care who they work for or what they work for, what industry they work for. Anyone that comes in the comment section and says that I'm wrong, they're one of them people. I'm telling you right now, they are one of those people who basically gonna tell you I'm wrong. Even though like I said, I sat on the phone for 47 minutes. I even have it recorded on my laptop. So before you even come in my comment section saying I'm wrong, just tread lightly because I always keep my motherfucking receipts. Now, when you file a lawsuit, what does this do? This creates an a stoppage to collection attempts because what you're doing is basically saying, hold up, wait a minute. Now, prior to filing a federal lawsuit in United States District Court, you must particularly do one or two things. Number one, you must offer them notice. The rule is why people don't understand this, why I say this time and time again. You cannot sue an entity without putting them on notice and giving them what's called grace and notice. See, before I go to this lawsuit, I'm giving you a chance to remedy the situation. Now, if you pay attention to my words and you look up these definitions of remedy, good faith, notice, you'll see exactly what I'm talking about and how all the Tetris blocks align. So once you do that, you send them the notice of default. Well, I sent this to you so many days ago, and right now I understand I'm not going to get any remedy from you because you told me in but so many words, either by acquiescence or either by verbiage and phone call, that you said that I am not going to honor this agreement. So now I have nothing more than to do one thing: redress of grievance. I have to take you to federal court. What does this do? This puts you in a period of grace because, at the same token, one thing I will tell people, and yes, I do encourage lawsuits against corporations for their abusive practices. Yes, I do. I will advocate for that wholeheartedly on my channel. Don't care. Don't give a fuck what nobody says. Because they don't care if they foreclose on you. They don't care if you don't have nowhere to stay. They don't care. Commerce is heartless. So let's not be sentimental with these people because they're not sentimental with you. Okay? Let's get that straight. Now, what you do is you turn around, you file a lawsuit. This stops all collection attempts because you're filing a lawsuit based upon Fair Debt Collection Practices Act. In other words, once a suit is filed, now it becomes a legal controversy, which also puts an estoppel on any action that they would wish to take against you in regards to trying to do a foreclosure because you already jumped first. Checkmate. See what I'm saying? So once you're in federal court, they no longer call you, they no longer respond to you, they don't talk to you anymore. Their job and their obligation now is to respond to the respective code and to respond to the respective code sections. And then they don't send it to you, they send it to the federal court because they have up to 30 days to respond, which means that at any time that they will contact you from the time of the initial filing, once you get your case number in the federal district court, basically they're not to contact you. Violation of the Fair Debt Collection Practices Act. If they contact you after a lawsuit, that constitutes harassment. Okay? So now when you file a lawsuit, basically what they have to do is one of two things. Either submit the deed and you'll file a motion to quash, basically saying, hey, well, you know what? I got what I need. Or you can just be relentless, such as myself. And you can just sue for damages. See what I'm saying? And you can also sue for all the money that you actually paid towards the fraudulent contract because you can prove for material interest that the contract was fraudulent from its inception. So what does this do? This makes them try to make it seem like, oh, it's going to affect your credit. Well, then that's basically that's misrepresentation. Look up the word misrepresentation in Black's Law Dictionary, you'll see exactly what I'm saying. So misrepresentation in Black's Law Dictionary means you basically did some deceitful and misleading practices in regards to the contract. Basically, it was a contract. So once the federal court gets involved, 9 times out of 10, I will tell people this though. See, the way I litigate and the way I stylize the pleadings and the way I've done it in my own life, and I have my wife to prove it, and I have my life to prove it. At the same token, I don't deal with the federal court the way I stylize it because I stylize it in such a way where you can't argue with it. You can't. You can't argue with it. You cannot argue with it at all. And one of those things is just that courts protect the banks. Banks protect the courts because they are both one and the same. So if your case goes before a federal judge in any instance or a federal magistrate or hearing or whatever, before it gets to a district court judge, your case now goes on record. So the thing is, once your case goes on record and you have a number, it's over with. The case has been assigned a number. The court clerk assigns it a number, it's on record. Now, however it's resolved prior to any hearing or any type of date or settlement prior to trial is a different story. Each case varies, each district varies, each attorney varies, each judge varies. It is what it is. However, the law still remains the same. You just have to stick to your guns and take these people to court. That's the only way you're going to get your remedy. Not joking, not BSing, just keeping it 1,000. That's just the way it's going to be. That's in less than 16 minutes. Simple as that. They never loaned you anything, people. They never loaned you anything. They never loaned you anything. In order for them to prove that they loaned you anything, they must provide any sort of contractual instrument that basically said that they gave you anything commensurate, which means equal. If you look up commensurate in Black's Law Dictionary, you'll see what I'm saying. Of any value in which you said that you loaned me. So if you say you gave me $100,000 loan, then where is the instrument proving that you did such? Your word is just not enough. Where is the receipt? Where's the account receivables? Where's the receipt? See what I'm saying? Where is the receipt? It's nowhere to be found, which is one of the reasons why they can't validate a debt, which is one of the reasons why a lot of people who pay mortgages are stuck in a trap, in an illusion, making themselves believe that they are obligated to something that is otherwise fraudulent. So, people who watch this video, if you would like help with this process, because it's a lot of things I'm just not going to say online for obvious reasons. Hijack is hijack, YouTube shadow bans. It is what it is. Certain stuff I'm not going to say. Just email me in the email section. Please, serious inquiries only. I don't have time to read through emails. I've been dealing with people who've contacted me. I've contacted them, and for some odd reason they think I'm their employee. Let's get one thing straight. Let's not get it fucked up. I don't work for nobody, okay? If I tell you to contact me, it is at my best interest at the time that I'm available to contact you. It's not the other way around, okay? Especially, especially, especialito if you didn't pay me for my motherfucking services. Please do not ever think that I work for you and I must answer your motherfucking emails at the drop of a dime. I promise you, you will be highly disappointed. And I say this with the utmost humility. Don't get it messed up. But when I say serious inquiries only, that's what I mean. There's 24 hours in the day and I have a family, which means that most of my time is divided. So listen, what my time is my time, for my time is my time. I don't like my time being wasted, period. So with that being said, if you want more information or you have problems, or even if you're in foreclosure proceedings and so forth and so on, it is A-OK. There's still a remedy for it. You just have to be able to lock in and be diligent enough to be able to execute this with proper assistance and guidance, which I assist with. And yes, people, it does come with the fee. You see what I'm saying? Serious, because it sounds easy on the video, but it's very arduous work. You see what I'm saying? If you want it to be airtight, simple as that. And my expertise in my own personal life, I use it myself. So ain't a damn thing a soul can say that I'm wrong or anything, because I use it myself. See what I'm saying? I get all that stuff charged off because I know what to say and I know how to word it and I know what venue to put it in. See what I'm saying? I don't argue with those people on a spectrum of trying to argue a debt. We never argue debt matters. We only argue instruments, proof. We don't argue what someone says you are. We argue the proofs, and that's my expertise. And yes, you will pay for my expertise. No ifs, ands, or buts about it. If you can't, it is what it is. Enjoy the video, enjoy the content. But if you need help and assistance within regards to this mortgage process, please feel free to do so. You know what I'm saying? Email me. My email is usually in the video description and it's usually in the comment section. I usually leave both of them. I leave my Gmail and I also leave my Proton mail. I also implore people to support the channel. You know what I'm saying? Content, it is what it is. Support the channel. This is my content. I do this out the kindness of my own heart. I already said it in the previous videos. It is what it is. And if you want to save your ass, you better invest. Simple as that. That's just me being real. Now, if you don't, hey, hey, swallow the blue pill, go back to bed, act like nothing I ever said on this video was even relevant. Like I never even said anything at all. But if you want to be serious about your self affirmation and you want to be serious about your dedication and you get yourself out of a debtful situation and you want to have that freedom and that peace and you want to have that deed or you want to get that title, whatever it is, for whatever commercial reason you may have, then please tap in. Like I said, I leave my email in the video description. Simple as that. I make it very simple. In the subject line, please leave mortgage package, please. Please leave mortgage package in the subject line so I know exactly what the hell you're talking about. And in regards to anybody who leaves the email, please leave in the subject. It don't take nothing for you to stop and just leave something in the subject line, whether it be for a consultation, whether it be for services, whether it be for materials, whether it be for a I it just leave in the subject line so I know what I'm saying. And please leave a number in which I can reach you at in a good time in which I can reach you. Let's make this shit as easy as we can, people. Because my life, I don't like it complicated. I like things simplistic. I like things cut and dry. So, in the subject line, please put mortgage package slash services. Simple as that. That's all you got to do. It's just that easy. Brief description and the number which I can reach you at will get you on your road. Simple as that, people. Easy peasy. Right? So me, I'm getting ready to go to enjoy the rest of my id. And y'all stay tuned. Like I said, I just broke it down. So simple. You know how to contact me. It is what it is. Peace, light, love. Agents, fuck you. It is what it is. Y'all take care. See y'all soon.